Powerful businessman's daughter disrespects court. Judge destroys her arrogance. By the end of this hearing, a powerful family's name would mean nothing. The private drivers would stop waiting outside. The security teams would step back. And a young woman who had never once heard the word no spoken to her with consequence would learn quietly and without ceremony what accountability feels like. At exactly 9:02 a.m. on Monday, March 11, 2024, the bailiff called Courtroom 4B to order inside the Jefferson County Superior Court. The room rose together, benches creaking softly as people stood. There were no cameras allowed inside, no live streams, no flashing lights, just wood-paneled walls, a state seal mounted behind the bench, and a judge who had taken his seat the same way for nearly 3 decades, without haste, without drama. I waited until the room settled before speaking. "This court is now in session," I said calmly. "You may be seated." My voice was even, unhurried. I did not raise it. I never do. Volume has never been necessary in a room where the law already carries weight. I reminded everyone present why we were here, not theatrically, not emotionally, simply as a matter of principle. "This courtroom operates on one standard," I said. "Respect for the law, respect for each other, and equality under the law. Wealth does not change that. Status does not change that. Family names do not change that. Inside this room, everyone stands on the same ground." I looked down briefly at the file in front of me before raising my eyes to the defense table. The defendant sat there with her arms crossed loosely, posture relaxed to the point of indifference. Her name was Olivia Harper, 22 years old, born and raised in Brookline Heights, one of the wealthiest neighborhoods in the county. Private schools, international travel, a trust fund established before her first birthday. Her father, Daniel Harper, was a regional real estate developer whose company owned commercial properties across 3 states. His name carried influence in certain rooms, fundraising dinners, political events, charity galas, but not here. Miss Harper wore a tailored blazer over a fitted top, hair styled deliberately but casually, as if she were attending a brunch rather than a court appearance. Her phone sat face down on the table, a small detail that would later matter more than anyone in the room realized. She glanced around the courtroom as if taking inventory, who was watching, who mattered, who didn't. When her eyes met mine, there was no fear there, no uncertainty, just mild annoyance. That, too, would change. I outlined the purpose of the hearing. 2 criminal counts before the court. One related to reckless driving and obstruction. The second tied to conduct occurring after release, while the case was pending. Both incidents documented, both supported by evidence, both preventable. "Ms. Harper," I said, "and today is not about who your family is. It is about what you did, and what you did next." Her attorney shifted slightly, but said nothing. He was experienced, well prepared. He understood that this was not the moment for argument. The first incident occurred on Friday, January 19, 2024, at approximately 10:47 p.m. The location was Cedar Ridge Parkway, a 4-lane road cutting through a mixed residential and commercial area on the east side of the city. The speed limit was posted clearly at 35 miles per hour. Street lights lined the road at regular intervals. Traffic was moderate. The weather was clear, the pavement dry. Ms. Harper was driving a white 2023 Range Rover Sport registered under a family-owned holding company. According to the vehicle's onboard data and later corroborated by traffic camera footage, the car was traveling at 63 miles per hour when it passed the intersection of Cedar Ridge and Milton Avenue. That intersection sits less than 200 feet from a bus stop used primarily by service workers finishing late shifts and elderly residents returning from evening appointments. Officer Daniel Ruiz of the Jefferson City Police Department was parked in a marked patrol vehicle nearby, completing routine paperwork. He observed the vehicle pass at a speed inconsistent with traffic flow and initiated pursuit at 10:48 p.m. His body-worn camera activated automatically. At 10:49 p.m., Officer Ruiz engaged his emergency lights. The Range Rover did not immediately pull over. It continued for approximately 3 blocks before slowing and stopping near the entrance of a closed retail plaza. Officer Ruiz approached the driver's side calmly, Flashlight angled downward, posture professional. His camera captured everything. "Good evening," he said. "The reason for the stop is your speed. Do you know how fast you were going?" Miss Harper did not answer immediately. She smiled briefly and reached for her phone. "Do you know who my dad is?" she asked. The words were not shouted. They didn't need to be. They were delivered casually, as if the answer should have resolved the situation instantly. Officer Ruiz asked for her license and registration. She sighed audibly, rolled her eyes, filmed him. "I was literally just going with traffic," she said, angling her phone upward. "This is harassment." The camera footage shows her scrolling briefly, then tapping the screen. Later analysis would confirm she had begun recording a video for her social media account. At the time, that account had approximately 38,000 followers across multiple platforms. Officer Ruiz remained composed. He explained the speed recorded. He asked again for documentation. Ms. Harper laughed. "You guys always do this," she said, "picking on people for no reason." At 10:53 p.m., Officer Ruiz requested she step out of the vehicle. She refused initially, stating, "I'm not getting out for this. You haven't even told me what law I broke." The exchange lasted 6 minutes. The tone never escalated on the officer's side. On hers, it did, subtly at first, sarcasm, dismissiveness, mockery. Eventually, she complied. The citation issued included reckless driving and failure to comply with a lawful order. She was released at 11:02 p.m. What followed that night would have ended many cases quietly. It did not end this one. At 12:17 a.m., less than 90 minutes after the stop, Ms. Harper uploaded a video to her public social media account. The clip was 32 seconds long. It featured edited footage of the stop, overlaid with text mocking the officer and the department. The caption read, "When small-town cops get bored and think they matter." By 8 a.m. the next morning, the video had over 112,000 views. By noon, it was 300,000. Comments ranged from amusement to outrage. Some praised her confidence. Others criticized her behavior. She responded selectively, liking comments that insulted law enforcement and replying with laughing emojis. I watched that video later, alone in chambers. Not because it offended me, because it revealed something important. This was not a lapse in judgment. It was a pattern. Ms. Harper was arraigned on January 29, 2024. She was released on her own recognizance with explicit conditions: no further violations, no harassment of involved parties, no public commentary intended to interfere with proceedings. She acknowledged those conditions, verbally, on the record. 19 days later, on February 17, 2024, at 3:26 p.m., she stood outside the Jefferson County Courthouse with her phone held high, live streaming. She titled the stream, "Let's Talk About Fake Justice." That second incident is where this case crossed a line, and as I looked at Ms. Harper sitting before me that morning, posture still relaxed, expression unchanged, I already knew something she did not. Mercy had been available once. It would not be offered again. I closed the file gently and looked back up. "Ms. Harper," I said, "we are going to take our time today, and we are going to be precise." The room was silent, and we had only just begun. At 3:26 p.m. on Saturday, February 17, 2024, the steps of the Jefferson County Courthouse were crowded in the way they often are on weekends. Families waiting for rides, couples cutting through the plaza, a few people seated on the low stone walls checking their phones. It was an ordinary afternoon, cold but bright. The temperature sat at 41 degrees with a steady wind moving down Grant Avenue. Ms. Harper stood near the south entrance, just beneath the bronze lettering spelling out the courthouse name. She wore sunglasses despite the overcast sky and held her phone at arm's length, camera facing her. The live stream began without warning. "Okay, so," she said, smiling slightly, "I'm outside the courthouse right now because apparently standing up for yourself is a crime." The video was broadcast to her followers in real time. At that moment, her primary account had grown to just over 41,000 followers. Notifications began popping up instantly. Comments, likes, shares. "I've got court coming up," she continued, lowering her voice conspiratorially. for literally nothing. A cop's feelings got hurt, and now they want to make an example out of me," she laughed. Behind her, the courthouse doors opened and closed as people passed. A uniformed court security officer stood approximately 20 feet away, assigned to exterior monitoring. He glanced toward her briefly, noted the phone, and returned his attention to the crowd. There was no confrontation, no provocation. At 3:29 p.m., Ms. Harper pivoted the camera away from herself and panned slowly across the building. "This place," she said, "is all about control. Old men, old rules, and no accountability." She zoomed in on the entrance, capturing the security checkpoint through the glass. "You see that?" she asked her viewers. "That's power pretending to be order." Comments began scrolling rapidly. Some urged her to stop, others encouraged her. She read them aloud selectively, laughing, nodding, feeding the moment. At 3:32 p.m., she crossed the line that mattered. "So here's the thing," she said, voice sharpening. "I'm not scared. They can't touch me. They never do." She tapped the screen, highlighting a comment that read, "They'll back down." "Exactly," Ms. Harper replied. "They always do." The live stream lasted 11 minutes and 42 seconds. During that time, she repeatedly referenced her pending case, mocked the officer involved by name, and referred to the court as a performance for people who don't know better. At 3:38 p.m., she ended the stream with a smirk. "I'll let you know how it goes," she said. Spoiler, I'll be fine. The video was saved automatically and reposted across her platforms. By midnight, it had been viewed over 520,000 times. The following Monday morning, February 19, 2024, my clerk placed a supplemental report on my desk at 8:14 a.m. It included certified copies of the live stream, transcripts, timestamps, and a violation notice submitted by the prosecution citing breach of release conditions. I read every word, not quickly, not emotionally, carefully. By the time Ms. Harper returned to court for this hearing, the matter was no longer limited to reckless driving. It was about defiance, public, intentional, and calculated. Back in courtroom 4B, I listened as the prosecution laid out the evidence step by step. Screenshots, metadata, time-stamped clips, no embellishment, no commentary. Ms. Harper watched, expression unchanged. Occasionally, she leaned toward her attorney and whispered. Once, she smiled faintly when a clip of her own video played. That moment did not go unnoticed. "Ms. Harper," I said quietly after the playback ended, "do you recognize the footage shown?" "Yes," she replied. "It's my account." "And do you deny posting it?" "No." "Do you deny referencing your pending case while on release?" She paused, then shrugged slightly. "I was just talking. I didn't threaten anyone." I nodded. "That wasn't my question." She shifted in her chair. "I didn't think it mattered," she said. "I mean, it's not like I lied." That sentence stayed with me. I looked down at my notes, then back up. On January 29, 2024, at 10:11 a.m., I said, "You stood in this courtroom and acknowledged specific conditions of release. One of those conditions was that you would not make public statements intended to influence proceedings or intimidate involved parties. Do you remember that?" "Yes," she said. "But there is no but," I replied, still calm. "There is memory or there is not." She exhaled sharply. "I remember." The courtroom was silent again, not tense, focused. At that point, the prosecution requested consideration of an additional charge related to interference and requested revocation of release. I did not rule immediately. Instead, I asked for the record of Ms. Harper's conduct following the live stream. What came next was revealing. On February 18, 2024, at 9:07 a.m., Ms. Harper posted a follow-up story. The text read, "They hate when you don't bow." At 2:41 p.m. the same day, she posted a poll asking her followers whether she should keep exposing them or let it go. Over 18,000 people voted. 72% selected keep exposing. At 7:52 p.m., she shared a direct message from an unknown follower praising her for standing up to the system. She replied publicly with a heart emoji. None of this was hidden. None of it was accidental. It painted a clear picture. Still, The law requires restraint, precision, proportionality. I issued a formal warning that day, February 21st, 2024, on the record, in plain language. Ms. Harper, I said then, this court is giving you an opportunity to correct course. Any further violation, any public conduct demonstrating contempt for these proceedings will be treated as willful. She nodded. Her attorney thanked the court. She was released again. That decision weighed on me more than most, because warnings only matter to those who understand consequence. On March 2nd, 2024, at 11:18 p.m., Ms. Harper attended a private party at a downtown loft on West Calder Street. According to witness statements and later video evidence, alcohol was present, music was loud, phones were everywhere. At 11:41 p.m., she appeared in the background of a video posted by another attendee. She was holding a drink and laughing. At 11:43 p.m., someone off camera asked, "What happened with court?" Ms. Harper turned toward the phone. "Oh, that," she said. "They're trying to scare me. It's cute." She raised her glass. "To fake consequences." The clip lasted 9 seconds. It was enough. The video was deleted within an hour, but not before being captured and preserved. When it reached my desk on March 4, 2024, at 7:56 a.m., I closed the file and sat back in my chair. There was no anger, no surprise, only clarity. By the time we reconvened on March 11, 2024, this was no longer a question of whether Ms. Harper understood the court's authority. She understood it perfectly. She simply believed it did not apply to her. As she sat before me now, legs crossed, gaze steady, I spoke again. "Ms. Harper," I said, "you were given clear boundaries. You crossed them. Then you crossed them again." She leaned forward slightly. "I didn't hurt anyone," she said. "This feels extreme." I studied her face. 22 years old, intelligent, confident, untouched by consequence. "This court is not reacting," I replied. "It is responding." I paused, allowing the words to settle. "And we are not finished." Her attorney straightened in his chair. The air in the room changed, not dramatically, but decisively, because the final evidence had not yet been discussed. And when it was, the path forward would narrow to a single outcome. I glanced at the clock. 10:47 a.m. Plenty of time left. At 10:52 a.m., I asked the clerk to mark the final exhibit into the record. The courtroom screens remained dark for a moment, the quiet stretching just long enough to feel intentional. Ms. Harper shifted in her seat, uncrossing her legs for the first time since the hearing began. Her confidence had not vanished, but it had narrowed, focused itself. She knew something was coming. The exhibit was labeled simply, State's Exhibit 12. It was a compilation, short clips, screen recordings, metadata overlays, timestamps verified independently by the department's digital forensics unit. The first clip began at 11:41 p.m. on March 2nd, 2024, inside the West Calder Street loft. The audio was clear. Ms. Harper's voice was unmistakable. "They're trying to scare me," she said. "It's cute." The second clip followed immediately. Same location, same outfit, a different phone angle. "To fake consequences." The words hung in the room after the clip ended, louder in silence than they had been at the party. Ms. Harper looked at the screen, then away. Her jaw tightened slightly. I did not speak right away. I let the evidence exist on its own. At 10:56 a.m., I addressed her again. "Ms. Harper," I said, "do you dispute the authenticity of this footage?" She shook her head once. "No." "Do you deny that this statement was made after a formal warning from this court?" "No." "Do you deny that this occurred while you were under active conditions of release?" Her voice was quieter when she answered, "No." I nodded and turned a page in the file. "In this courtroom," I said, "we distinguish between ignorance and defiance. Ignorance can be corrected. Defiance must be confronted." She looked up at me then, really looked, for the first time that morning. "I didn't think it would go this far," she said. That sentence, more than any other, captured the entire case. I leaned back slightly, hands folded. "Ms. Harper," I said, "this court has seen people make mistakes. I have seen fear. I have seen regret. I have seen genuine remorse. What I have not seen from you is recognition." The room was still. Even the air conditioning seemed to soften. I want to be very clear, I continued. This is not about a single traffic stop. This is not about speech. This is about repeated, deliberate choices made after you were told, plainly, where the line was. I paused. And you stepped over it anyway. I spoke then about things I rarely mention, about the stretch of Cedar Ridge Parkway where she drove 63 miles per hour, about the bus stop 20 yards from the intersection, about the elderly man struck there 3 years earlier by a distracted driver, about the child I once watched testify after losing a parent to reckless speed, not emotionally, factually. Rules exist, I said, not to limit freedom, but to prevent harm. I looked at her again. And privilege, I added, becomes dangerous when it convinces someone they are immune from consequence. Ms. Harper's attorney stood briefly, asked to speak. I allowed it. He spoke of her age, her lack of prior convictions, her charitable work, her potential. I listened. When he finished, I nodded once. At 11:14 a.m., I said, "This court is prepared to rule." Ms. Harper's hands tightened together in her lap. I delivered the verdict slowly, clearly. On count 1, reckless driving and failure to comply with a lawful order, this court finds the defendant guilty. She inhaled sharply. On count 2, violation of release conditions through repeated public interference and contemptuous conduct, this court finds the defendant guilty. No reaction followed, just stillness. Then came sentencing. This court imposes the following, I said. 30 days in county jail, consecutive, not concurrent, no early release. Her head snapped up. A fine of $4,500, reflecting statutory limits and proportional accountability. Her attorney placed a hand lightly on the table. A 12-month suspension of driving privileges effective immediately. Her lips parted, but no words came. 120 hours of community service to be completed in a court-approved public safety program. I paused before the final condition. And mandatory participation in a court-directed responsibility seminar focused on digital conduct and civic accountability. I explained each sentence. Why jail was necessary, why fines alone were insufficient, why loss of driving privilege mattered, why community service was not punishment but exposure. This sentence, I said, is not designed to break you. It is designed to stop you. I looked directly at her, because the law cannot function if people believe it is optional. Ms. Harper's eyes filled, but no tears fell. She nodded slowly, once. I addressed the room then, not loudly, not dramatically. To parents, I said, understand that protection without accountability is not love. To young people, confidence is not immunity. And to families of influence, I said, this court will always see the individual, not the name. At 11:29 a.m., I nodded to the bailiff. Ms. Harper, I said, you are remanded into custody. She stood unsteady now, the performance finally over. As she was escorted from the courtroom, there was no applause, no commentary, just the quiet sound of footsteps moving away. I waited until the doors closed. This court is adjourned, I said. The gavel struck once, softly, and the room returned to ordinary silence, carrying with it a lesson that did not need to be repeated to be understood.